Welcome, good afternoon, and thank you for joining us to the second in a series of webinars and the first in a series of webinars about child custody. My name is Patricia Fersch. I'm a partner here at Fersch LLC. Today's topic is what to expect from a forensic examination, specifically in a child custody case. The seminar today is divided into 5 parts, and we have with us a very special guest, Dr. Paul Heimowitz, who you will be hearing from later on in the program. Before I tell you what each section will be, I wanted to outline when a forensic doctor is appointed in a disputed child custody case. So if there is a dispute as to legal decision-making, or otherwise known as legal custody, or physical custody, otherwise known as parenting time or time with the children, there will or possibly be a forensic doctor appointed to examine the parties. In addition, if there are issues presented by either party of drugs or alcohol abuse, domestic violence, claims of parental alienation by one or both parents, relocation as an issue, and certainly mental illness. The first part of the program will be presented by my partner, Maxine Donskoy. She will be answering these questions. What is a forensic examination? Who conducts the forensic examination? Who decides what the forensic can evaluate? And does the litigant have any input? The second part of the program will be a series of questions and answers between myself and Dr. Heimowitz. The third part of the program will be presented by Shane Duffy, Associate Attorney here in our office. He will be presenting the weight or how much importance does the forensic examination play in the ultimate determination of child custody by the judge. Does the judge read the report? And who gets or who's entitled to a copy of the report? And finally, Meryl Haft will be addressing what if the forensic report is negative towards you? What can you do, and what evidentiary issues in terms of if you want the forensic report to come into evidence, what can you do to keep some of it out or get it all in? I want to thank you for joining us. Our program represents our views and our views alone. These are not the views of the court system, OCA, the judges, other attorneys. These are our views. I also want to tell you that a recording of this seminar, if you want to refer back to it or tell other friends or family about it, will be available on our website. And finally, today, with the help of Associate Attorney Shane Duffy, our Instagram account went up, and you can find that Fersch Family Law, and it's a series of questions and answers very similar to what we're doing here today. So we hope that you will follow us. Without further ado, Ms. Maxine Donskoy with part 1.
Good afternoon, everyone. My name is Maxine Donskoy. I am a partner here at Fersch LLC, and as Pat mentioned, I will be discussing what is a forensic examination, who conducts the forensic examination, who decides what the forensic can evaluate, and whether or not a litigant may have any input in the forensic examination. So you may be wondering, what is a forensic evaluation? A forensic evaluation or examination is an evaluation by a mental health professional, either chosen mutually by both litigants or appointed by the court to provide a neutral evaluation of the litigants and the children or child and render a report. This report is written after seeing both parents separately on several occasions, the child or children, if the child is of age appropriate, and each parent with the child or children. A forensic evaluator is also likely to speak to third parties, such as the child's pediatrician, any current or former therapists, child care providers, and teachers. The forensic evaluator is likely to ask each party questions surrounding the parenting skills and the parent-child relationship of each party. The evaluator may also administer a series of psychological tests which examine the parties' personalities and emotional functioning, as well as each party's feelings towards the other as parents. That forensic evaluators may or may not make express recommendations. However, as Mr. Duffy will later discuss, the court is not bound by the forensics recommendations. However, the forensic report does offer the court direction and guidance relative to the parent that should be afforded legal and/or physical custody of a child. And that guidance includes the child's relationship with each parent, the relationship between the parties as parents, the ability of each parent to make appropriate decisions for the child or children, and any risk factors that may impact child custody or parenting time, and whether one parent will promote a relationship between the child and the other parent. Now, you may also be wondering, who conducts the forensic examination? Could my personal therapist or social worker possibly conduct the forensic examination? No. There's a panel of social workers, qualified social workers, psychologists, and psychiatrists that has been established in the first and second departments. At the forefront, I will say that we are only discussing the first and second department here. There are other judicial departments, but we will only be discussing the first department seated in Manhattan, which covers Bronx County and New York County, and the second department, which is seated in Brooklyn, which covers Queens County, Kings County, Richmond County, Nassau and Suffolk counties, and what we consider upstate, Dutchess, Orange, Putnam, Rockland, and Westchester counties. And so the panel, which is in the directory of mental health professionals available via the appellate division. I have provided a link here in the slides, and if you need more information, you can always email me after the webinar and I'll gladly assist you in gathering this information. And in order to be on this panel of qualified mental health professionals, some, not all, but some of the requirements that the mental health professional must have is A, either be a psychologist, psychiatrist, or social worker licensed by the state of New York, B, complete 6 hours of introductory training approved by the presiding justices of the appellate division of the first and second departments, and C, demonstrate that he or she has forensic experience, which includes having testified as an expert or having submitted a clinical report in connection with one or more of the following types of court proceedings: custody and visitation, persons in need of supervision, child abuse and neglect, delinquency, termination of parental rights, family offense, and adoption. Now, you may be wondering, who decides what the forensic can evaluate? The court. The court appointing the mental health professional issues a written order setting forth the terms and conditions of the appointment. Orders may include payment, the method and rate of compensation, and by whom such compensation is to be paid. There is a schedule of fees on the appellate division website. However, there are forensic evaluators who are also ordered private pay. That's usually done in the Supreme Court, and there are also 18B forensic evaluators. So there are different forms of payments and rates as well. The order will include the names and relationships of the people who are to be examined and their contact information. It will also likely include that the forensic evaluator may interview any extended family members or third parties affiliated with either party's household if that is deemed relevant. It will also likely include that each party is to provide releases so that the evaluator may speak with healthcare providers, pediatricians, therapists, and procure any records, reports, or material relevant to the parties or children that the evaluator believes will be an assistance to him or her in conducting the evaluation. In addition, the order will include that counsel is to provide any documents that were filed in the case. However, it will also most likely include that counsel shall not have any communication with the forensic absent just sending those documents, scheduling appointments, or assisting with payment issues. So you can't have your attorney speak on your behalf or have an appointment or meeting with the forensic. These are meetings between you and the forensic evaluator, and your attorney can only assist in payment issues, scheduling, or providing documents that have been filed with the court. Now, the forensic may or may not include that the forensic evaluator is to provide a recommendation as to which parent should have legal or physical custody. There are certain orders which say the forensic evaluator shall not provide a recommendation. However, there are orders as well that say that the forensic shall provide. So it really depends on the court and the judge and the weight that the court and the judge will give to such recommendation. And now you may be wondering, do I, as the litigant, have any input as to what the forensic will evaluate or examine? And the answer is yes. If there are any special issues in your particular case, you should let them be known prior to the order being issued, and you should let your counsel raise these issues. And these special issues include, but are not limited to, mental illness, domestic violence, interference with parental rights, substance abuse, parental alienation, and even relocation outside of the state. So at this time, it is my pleasure and honor to introduce partner Patricia Fersch, who will be speaking with Dr. Paul Heimowitz, a qualified forensic evaluator, and be asking relevant necessary questions. Okay, thank you very much. Sorry.
Good afternoon again, and specifically good afternoon, Dr. Heimowitz. So the first question that we have for you, and the questions are up on the screen, and just one sort of note, in the event that we go over the hour, we will stay a few extra minutes to answer any questions you may have. So if anyone needs to rush off, just remember it is all recorded. And also all questions are confidential. So Doctor, if any, what is your professional relationship with or to the litigants?
Well, our code of responsibilities in this regard are that we should be wearing only one hat, in the sense that we're rendering a forensic service to parents, presumably strangers to us, that we have no other prior relationship with, nor will we engage in other activities during the course of the evaluation. Usually I'm referring to therapeutic advice giving, referrals, and so forth. Generally, that is outside of the scope of the limited role of the evaluator.
Thank you. Now, how do you go about conducting the investigation? In other words, how do you obtain information from the litigants?
The heart of the forensic process are individual interviews with each parent, which are kind of counterbalanced. We see one parent, we see the other, we go back and forth anywhere from 3 to 7 or 8 hours of interview time. Generally, the parent has to be advised of their rights in terms of engaging in the process, essentially that they are waiving the usual confidentiality that they would have with a professional. Here, that is not the case, that this is kind of an open process. And we also, I think, advise the parent that we are interested in as honest an assessment as we can make. So we're asking people to present their strengths as well as their weaknesses as parents. And of course, they will be telling us about the being critical of the other parent, the adversary, but we're asking also, if possible, for them to provide some kind of balance in terms of what they're saying about the other parent. other sources of information, because in a forensic process, we're not simply taking the word of the litigant the way, as for example, in a therapy process, we are pretty much accepting what people are saying. Here, we're taking a kind of skeptical attitude, and we do obtain alternate sources of information, which usually include collateral sources, other professionals who've known the parties or know the children, possibly friends and family. Each litigant can provide a list of potential collaterals. Document review will include court papers, affidavits, petitions, sometimes communication between the parties. And then we have other additional sources of data that we may use, such as psychological testing and so forth. But the information, in a certain way, the center of it is what the litigants tell us.
Now, do you give the litigants a questionnaire to complete prior to beginning the interviews?
I don't. Some evaluators may. We don't have a specific directive about whether to do that or not, and I don't know of any specific generally used questionnaires. So I prefer to do it on a case-specific basis in the form of question and answer. Once there are special issues involved, which have been alluded to already, we can go over those again, but there are risk assessment protocols that have been developed by some of the organizations, such as AFCC, which do provide guidelines on some of the specialized issues, such as domestic violence, such as relocation, 6 or 7 that you've mentioned.
Thank you. Now, do you meet at any time with the parents together? In other words, in a single interview?
Generally, that's an option. It's not something that's would be part of our advisory guidelines. I would say more often than not, I will do that. And it's an interesting opportunity to see the parties together, not always pleasant, but you know, it is an opportunity to see them on the ground running. The particular exceptions to that would be where there are restraining orders, where there are issues of domestic violence, where one parent is really in some way legitimately fearful of the other parent. That would have to be done in a kind of a particular way. I mean, sometimes I even do that, where I'll have the parties arrive and depart from the office with some kind of time gradation, so that they don't that they can come and go without running into the other parent.
What about home visits? Do you make home visits to the litigants' homes?
Home visits are, again, not a necessary part of the process, but often quite valuable. It does give you a chance, particularly with younger children, let's say 5 or 6 years of age and under, to see the child in a more comfortable environment, to see the kind of home the parent has, sometimes a little bit less of a guarded take on the parent-child relationship. There are sometimes logistical barriers to doing home visits, depending on where the home is located, depending on the time frame, depending on the expense involved. So I would say it's about half the time that I would do home visits. And
how during COVID are these interviews being conducted by you?
It's a tough one. I'm doing interviews remotely. Of course, collaterals are done by phone generally anyway. Document review can still go on. The interviews with adults remotely, I think, have gone fairly well. I have not tried to see the parents together on a Zoom call, but certainly that would be possible. I've also interviewed children alone, where they're certainly 8, 9, 10 years of age and older. Those interviews go fairly well, as far as I'm concerned, remotely. The ability to observe a parent-child interaction, particularly a child under the age of 6 or 7, is somewhat compromised by if it's restricted to a remote process, which has been the case for me currently. So I do think there are some limitations in terms of what we can currently do. Some people have advised finding a way to observe the parent-child live, perhaps outdoors, certainly for during the summer months and early fall, that is a possibility. Although it's a little harder for the forensic to control the observations the way one can in the office.
And finally, on this topic, what you mentioned collaterals. Who are the collaterals you are most likely to interview by telephone, I believe you said?
Yes, certainly, and I suppose there's a bit of a hierarchy in terms of priority. I would certainly give priority to any therapists that have been involved. If there's a therapist who has worked as a couples counselor between the couple, that would be particularly valuable, as presumably they would have somewhat more of a neutral take on the family. Child therapists, people who've been working with the children, would also be of the highest priority. Next on the list might be professionals who've had service relationships with the children, pediatrician, teachers, in addition to therapists. A little further down on the list would be nannies, people who've been living in the home, working with the family for some period of time, obviously valuable. And then there are occasions where a grandparent, for example, who's doing a fair amount of the parenting, sometimes siblings of the parents. Sometimes there are older children of one or the other parent who are not subjects to the custody evaluation, but would be valuable as collaterals. So sometimes there are kind of random friends and family that might be included. The parties usually provide a list of collaterals, and then I have to redirect them a bit sometimes in terms of who they have on the list. I don't want to speak necessarily to somebody's best friend, somebody's mother, who's going to provide sort of predictable support for the litigant.
And are you a mandated reporter?
Well, I am a mandated reporter, as any licensed mental health professional is, so that there is an obligation in questions of child neglect or abuse may come up in the course of the evaluation, that as a professional, I would be obligated to contact protective services and phone in a report. I would say, personally at least, I would err on the side of not doing that if at all possible, as it would have, I think, a prejudicial effect on the evaluation. But it is a New York State mandate that a mental health professional is a mandated reporter.
Now, when the court order lists issues related to domestic violence, and they appear on the screen here: parental alienation, substance abuse, relocation, and or mental health issues. Is there anything different or in addition to what you've already described that takes place during the forensic evaluation?
Right. By the way, I would add, I think one other key one, and we probably could generate some others too, but allegations of child sexual abuse, I think probably would be one of these kind of key areas. Each of these have some specialty areas that one would go into, either using a series of questionnaires that have been developed by organizations such as, which I've alluded to, AFCC, where they have some risk assessment protocols with 40 or 50 kind of questions, or at least topics that one should go into. There certainly might be the need to bring in an additional expert. I mean, the forensic expert has a more general expertise and presumably has had some experience with these areas. If one doesn't, and it's a case where it seems as if substance abuse, just to pick one, is highlighted as an issue, and the professional has no experience in that area, it might be a case where you don't take on such a case. On the other hand, presumably you have some general experience in the area of substance abuse, that can be an area where an additional expert can be consulted, for example, to do a specialized alcohol abuse evaluation, let's say of one or both parents.
Now, when you are called as a witness and are qualified as an expert, what generally is the area of expertise that you are qualified as to a court?
You know, they talk about different things. One would be the license, the affiliation, the professional affiliation. So I'm qualified as a clinical psychologist, a New York State licensed clinical psychologist. More specifically, generally, they qualify me as an expert in child custody evaluations.
And now, in the process of a forensic exam, can you make in your reporting a diagnosis of one of the litigants? And here specifically referring to a diagnosis as listed in the DSM-5. Is that part of this process or not?
Well, there's some controversy about that, as I believe that when a mental health and a forensic evaluation is done by the family courts, and they follow some similar procedures, if it's done through the family court, the mental health clinic in the family court, generally they routinely include DSM-5 diagnoses. My practice is generally to not include diagnoses unless it seems to be directly relevant to parenting. And that may come up as an issue if we have, for example, a parent with a serious mental illness, such as bipolar disorder. One issue may be how compliant is that parent with medication and treatment. So that's the kind of place where a diagnosis might be included, although even there, I would think that it would be somebody who would come into the forensic process with the pre-existing diagnosis made by a psychiatrist, a clinical psychiatrist, so that generally the diagnosing within the forensic process, I would tend to forego. A lot of the litigants in these cases have some aspects of a personality disorder, and again, that is not a specific diagnosis. It's just a kind of more generalized way of talking about certain people. To start diagnosing a parent as specifically having a narcissistic personality disorder, a paranoid personality disorder, a borderline personality disorder, the kind of thing that people often bring up about the adversary. Generally, we're going to refrain from specifically going through a DSM checklist and seeing if the person qualifies for the 7 or 8, let's say, criteria that would apply for a borderline personality disorder. I think we generally refrain from doing that and talk more about how the personality in general relates to parenting.
And can you make a credibility assessment of the individuals? In other words, can you write in your reporting, this person is truthful and everything, or, you know, and I'm exaggerating, obviously, everything that came out of this person's mouth was false. Can
Right.
Can you do that, or no?
The answer is generally no, and certainly in testimony, I've been advised that determination of credibility is left to the trier of fact, to the judge, and so generally we don't, in mental health, use the specific of credibility. That being said, you know, we do want to provide some indication, well, make an assessment and then provide some indication as to the validity, let's say, of what the person is saying to us. So that if we have a person who seems to be, you know, have a you know, a less than straightforward relationship with reality or with truth, that's going to come out in our evaluation. without using the word credibility. So I think it, it's not so far removed from what the judge is going to do, but we generally don't use that term.
And finally, are there any outlines or guidance that you use in terms of the conducting a forensic child custody evaluation?
Yeah, each of the professional organizations, in my case, the American Psychological Association, has guidelines for conducting child custody evaluations. They refer to these guidelines as advisory in nature. That is to say, there's not you don't have to do any one of these things in terms of the evaluation, but they would be advisory guidelines recommended by, let's say, the American Psychological Association. The American Psychiatric Association has such guidelines. And then this organization that I've referred to, AFCC, the Association of Conciliation Courts, also has a series of, again, fairly general guidelines.
Doctor, I want to thank you for this question and answer session. I hope it was helpful to everyone listening. And I'm asking you, of course, to stay with us so that if there are questions at the end, you can help answer them. So thank you so much. And I'd like to introduce next Mr. Shane Duffy, Associate Attorney, who's going to now talk about the weight the court gives to Dr. Heimowitz's hard work.
Good afternoon, everybody. My name is Shane Duffy, and the first topic I'm going to be discussing is how much weight will the courts give to a forensic evaluator's report. So for the purposes of this discussion, as Ms. Donskoy noted, we're just going to stick to the first department and the second judicial department. So just a quick refresher, the first department is only New York County and the Bronx County. So prior to 2005 in the first department, courts would generally defer to the forensic examiner's report if they made a recommendation as to child custody. This case here on the top left, matter of John A. versus Bridget M., started to change things. So in this case, the forensic examiner's report noted that the mother was trying to undermine the relationship between the father and their children. Despite knowing this in her report and then echoing this information in their testimony, the trial court found that the mother should be afforded primary physical custody of the children. On appeal, the appellate court held this bolded language here, that courts should be ever mindful that while the forensic expert may offer guidance and inform, the ultimate decision on any issue is a judicial function and not one for the expert. The appellate court also noted at this point that there was a large debate between the mental health community and the legal community as to how much weight courts should be affording to these recommendations made in the forensic examiner's report. So now we're going to jump forward to Jonathan R. versus Meredith S. This is a 2019 case, and this kind of reflects where the case law stands right now. And the key language to focus on here is that last sentence, that the court is not bound to follow the recommendation of the forensic evaluator. So the court will take the recommendation in the forensic evaluator's report, and it will give it some weight and use it as one factor in making its final custody recommendation. So now we're going to turn our attention to the case law in the second department. And just a quick refresher, that's Kings County, Queens County, Richmond County, and then upstate, which is Dutchess, Orange, Rockland, and Westchester. And then we also have Suffolk County as well. So the first case we're going to look at here is Baker versus Baker. This is a 2009 case here. So the key language to focus on is that the Supreme Court was not obligated to adopt the recommendation of the court-appointed forensic evaluator. And the court went on further to note that the recommendations of court-appointed experts and the position of the attorney for the child are factors to be considered and are entitled to some weight, but such recommendations and positions are not determinative and do not usurp the judgment of the trial judge. This is essentially saying that this is a decision for the court and not one for the forensic examiner alone. And now we're going to jump forward again to a more current case from 2019, which is echoing what we've been going over so far. And that's that a court is not automatically required to accept the recommendation of a court-appointed forensic evaluator, but must consider all of the relevant evidence. The court also noted in this case that the court must take into account the quality of the evaluator's methods and how they gather the information in their report when determining how much weight they give it. So that would be who they spoke to, where they spoke to them, and things like that. The next topic I'm going to get into is, does the judge assigned to my case read the forensic evaluator's report? And this answer is a lot shorter than the prior one, and that's just, it depends. Some judges will read it right away, and some judges will wait until they have the consent of both parties before reviewing the report. But what's of utmost interest to most litigants is, will they receive a copy of the forensic evaluator's report? So right now, there's no law in New York State that guarantees the right to have a copy or read the report. If the parties are given copies of the reports, an abuser could easily inflict more abuse on the parent by making the contents of the report public. As a result of this, the court closely guards these reports, and if they turn them over, generally to the attorneys, and the attorney must first sign an affirmation stating that they will not duplicate or release the report to anybody. Besides going to their attorney's office to review the report, they have one other option, which is sometimes the judges will allow litigants to come into the courtroom to review the report there. But the court does closely guard this information, and there was a high-profile case in 2014 wherein a neurosurgeon was caught in the courtroom trying to sneak out a copy of the forensic evaluator's report and was arrested and charged with contempt of court. So this is something the court takes very seriously. Right now there's proposed legislation at the state level wherein some people are pushing for parents to have the right to have a copy of this report. I think it's clear to see that there's problems to that. It's evident that parents will want to see the report and have a copy because it does have weight, and it is something that informs the judges when they're trying to make their final custody recommendation. But the contents of the report are generally very sensitive, and if any of them were to be made public, it could be harmful in other ways to people that might already be abused. At this time, I'm going to introduce Ms. Meryl Haft. She's a partner here at Fersch LLC, and she's going to discuss what you can do if the forensic report is bad for your case. Thank you.
Good afternoon, everyone. So sometimes the forensic report comes back and it's not as favorable as you would have hoped, or you interpret it to mean that it's going to be quote unquote bad for your case. So I'm going to talk about things that you can do if you're in that situation. So the most common thing that you would consider doing at this point would be hiring someone to engage in a peer review of that report. A peer review is when one party hires a rebuttal mental health professional, a psychologist or psychiatrist, to read and analyze the court-appointed forensic report to point out any deficits in the report, which can raise credibility and reliability issues. A peer reviewer may testify as to these deficiencies and or may assist one party's attorney in preparation for cross-examination. What does a peer review look for? So the first thing would be to consider the qualifications of the court-appointed evaluator. Usually this is not an issue, but perhaps there was a drug abuse issue, for example, and the evaluator is not experienced in evaluating that type of issue. That could be raised in a peer review. Did the court-appointed forensic follow the AFCC? The AFCC has model standards of practice for child custody evaluations. The link is listed here. But basically, this would be one way to attack a report if the evaluator did not follow these recommendations. Are there factual inconsistencies in the report? These reports can end up very long, 50 pages or more. So sometimes reading a report, you'll see that there are contradictions within that report. So if that's the case, a peer reviewer can point these out and perhaps raise issues of credibility or reliability. Looking at the scientific basis used to arrive at the conclusions is another way to attack a report. What tests were used by the evaluator, or perhaps which tests were not used that would have been helpful? Is the evaluation flawed in some way? Do the conclusions comport with the findings? Is there bias, perhaps, or a conflict of interest? Did the evaluator show some favoritism towards one party? And finally, were the collateral informants contacted? So at the beginning of a forensic evaluation, normally the evaluator will ask both parties to provide the names of certain people who may be able to provide information for the evaluator: teachers, relatives, perhaps the pediatrician. Did the evaluator contact these people? Or perhaps did the evaluator rely too heavily on one opinion of a collateral contact? So another option, which is perhaps almost unheard of, but not impossible, would be to engage a second forensic evaluator. Perhaps both sides are unhappy with the report that came back, or perhaps it's so flawed that the court, upon a motion, would grant the right for the parties to engage in a second forensic evaluation. So in the rare event a second evaluation is conducted, the expert is either agreed upon by the parties or would be appointed by the court, and his or her role roughly mirrors the original evaluator's approach: meeting with the parties and the children, contacting collaterals, and forming an independent opinion. Now, in the event that you don't have the right to a second forensic, a peer review is generally the way to go. A peer reviewer will not meet with the parties or the children, but may issue a written report. The peer reviewer will assist in preparing an attorney for cross-examination and can testify as an independent expert. The peer reviewer does not require consent of both parties or permission of the court. So if your case is going to trial, you'll need to consider some evidentiary issues about how the report comes into evidence. So you may want the report in evidence even if there are parts which are unfavorable to you, or perhaps you'd like to try to keep it out. A report comes into evidence only upon the consent of both parties or testimony of the forensic evaluator in order to do what's called laying a foundation to allow the report to come in. So you could potentially withhold consent if you did not want the report in and force the other side to call the forensic, although that comes with certain implications as well. You may also want to challenge the hearsay in the report. Here's a quick law school lesson. Hearsay is defined as any out-of-court statement offered for the truth of the matter asserted. So the collateral sources that were contacted by the forensic, those collaterals likely have provided statements to the forensic which may be embedded in the report. In order for those statements to come in, those people must be called as witnesses to testify as to the statements they made. If they're not called, these statements would be redacted as hearsay and therefore considered unreliable. Okay, we are now going to open things up to questions. These questions are strictly confidential and we will in no way disclose your identity. So if you have questions, please type them in the Q&A now. And I'm going to turn it over to Maxine Donskoy, who's going to lead the Q&A.
Thank you, Meryl. Now let's see if we have any questions. And I will invite Dr. Heimowitz back so that way he could answer any relevant questions as well. Okay. Okay. If one parent feels as though a mental health professional on the court-appointed panel is biased against them, can they request a different evaluator? So I believe that Meryl had discussed this issue in her presentation, that if you do feel there was bias, you can either attack the report through a peer review, or if you think that it was so biased that it allows for a second evaluation to occur, then you can make a motion to the court.
I mean, it sounded like the question might be if they, prior to the appointment of a forensic,
Okay.
perhaps they knew of one of the people on the panel that they had somehow, obviously if they had a direct experience with that person, they'd be able to disqualify that person. Suppose they knew of the person who had certain opinions that might be, it's a father's right person, it's a pro-mother person, and they knew that in some way from public statements and so forth. I suppose they could raise objections to the appointment of that person as a forensic. If that's the question, the answer is possibly with the help of the lawyer.
If I've divulged personal information in private one-on-one therapy sessions that could be potentially damaging to my ability to get custody, does my therapist have to share that information with the evaluator? Dr. Heimowitz?
Oh, I was hoping you were going to go first on that.
Well, you do have to sign HIPAA releases, and whenever there is a custody case, you do, open the door to your mental health being out in the open and all of that. So there may be, your privilege may be lost in that sense. What are your thoughts?
Yeah, it's actually a fairly complicated question because in my experience, therapists often see themselves as advocates for their patients. They're not necessarily concerned about the best interests of the children because they have a client to protect. So even though the litigant has released the information, the therapist can be selective in terms of what they reveal. Generally, either we don't ask for the actual notes because we just talk to the person, and if we do ask for the notes, therapy notes can be notoriously skimpy and generalized. Saw a patient today, discussed relationship issues, end of note for November 11th, that kind of thing. So I think it's complicated. If you can establish as the forensic a reasonable rapport with the therapist, hopefully you will get the disclosure of information. Hopefully the therapist will have some concern for the best interests of the children. But it's not always the case. So, you're sort of limited to what these therapists are willing or not willing to tell you.
Yes. Here's another question for you, Dr. Heimowitz. In your professional opinion, once you complete a forensic examination, does there come a point in time thereafter that the review becomes stale, requiring an update and/or a new review?
You're talking about not the peer review, but you mean the evaluation? Evaluation
by you.
Yeah, okay. So yes, I mean, that is fairly often the case. What's not the case is generally, I rarely have heard about a second evaluation being ordered right on the heels of the first one because nobody liked the first report. Generally, somebody likes the report, I mean, because it's going to, even if they don't like the report in toto, if it favors them, they're going to be pro-report. But certainly if and I don't think there's any strong guideline about this, but certainly, let's say a 2-year window with a young child, there's going to be the need for an update. And I would say fairly regularly, the courts might turn to the same forensic to do an update. It certainly would be more economical and save time and money. The downside is that that forensic may be prone, we're all human, to come out with sort of a similar take on the parties. So if you have, in other words, if you have an unfavorable evaluation, with your client, you may want to work hard to get a different forensic appointed for an update.
Let's see. Have substance abuse issues ramped up during COVID-19? What if a parent who did not previously have a substance abuse issue prior to COVID but is struggling with it now? How will they be evaluated, especially if they are aware of it and seeking treatment?
Well, a bunch of different questions there. First of all, look, this is in the scheme of things, it seems like COVID has gone on forever. Like we can't remember before COVID, but I have, I know what you know from reading the newspaper. It sounds like people are consuming more alcohol. Liquor stores are doing very well. It's been good for that business, but it's probably not always good for parenting when people are drinking more. Now, if a parent is seeking help during this period of time, I would think generally we look favorably. I mean, litigants don't always see it this way, but I would say in general, I can speak for most forensics, we look favorably upon someone who's seeking appropriate professional help. If they're acknowledging a substance abuse problem and they're getting help, and then maybe even submitting to one of the various detecting facilities that we have, such as SoberLink will provide, where a parent can actually be monitored in terms of drinking. Those are positives. If it's the other parent who's saying, my co-parent is drinking heavily during COVID, that's a different story that would have to be looked into. But I have no way of generalizing about that.
And similar to the question that we just answered, somebody says that they had a domestic abuse record in a relationship more than 10 years prior to being in the one that they are in now. They say, I resolved the issues through treatment and therapy. Would that record be taken into consideration by a forensic evaluator?
Well, yeah, yes and no. I mean, if the issue in the current evaluation was that the co-parent is victimizing the other parent, and there's domestic violence going on in the present, then the prior, even if it was 10 years ago, would be particularly relevant. If it's not being raised as a particular issue, but we know that dad, for example, had a relationship 10 years ago where there was domestic violence, dad got treatment, dad had an anger management protocol, I would think, again, that would be viewed at least neutrally, if not favorably, that the person got treatment for it. But all of these things are an open book, so the prior history is certainly going to be of some relevance.
Someone just asked, speaking to the fact that forensic evaluation can't make diagnosis, how can the forensic evaluator manage cluster B personalities as they relate to parenting if cluster Bs are master manipulators, often fooling therapists, judges, etc.?
Ouch. Look, there are people who can beat the system to some degree. They can beat, there are people who seem to be able to beat psychological testing, even when we have tests that have built-in validity indicators. There are people who seem to be able to do that, either because there's all kinds of information now available online, or because they're just very good at it. Then you hear as a forensic that, a year later, somebody tells you, by the way, Mr. Smith, who you thought was such a great guy, is still, stealing and manipulating and lying and so forth. So look, there's no guarantee about that. But on the other hand, we have a better shot at establishing some kind of truth than you would in an ordinary situation where, let's say, you're just a therapist and you're not dealing with collaterals, you're not looking at documents, and you're not hearing from the other party. Presumably the adversary is going to say, my spouse is a master manipulator and liar, and you've got to do something to smoke that out. And so you try to talk to as many people as you can. Now, if everybody says he's a great guy and he's fooled everyone, at a certain point, yes, I mean there is the small percentage of people who can get away with that, but that's not unique to a forensic evaluation. That's going to be true in the judicial process, in the therapy process, and in terms of people who choose to have as a partner to have a child.
And one more for you, Dr. Heimowitz. What if there are relatives who have been poisoned by one parent and are inclined to intentionally say negative things about the other parent? How does the system ensure that the process is fair?
Well, look, these are blood feuds. As the saying goes, blood calls out to blood. So generally, people are going to speak on behalf of their own. Grandma is not going to suddenly, vilify her son, and may never have liked the daughter-in-law anyway. So, I think we would take it for granted for the most part that family is going to stick up for their own. When they don't, it's actually quite interesting, and that can be a valuable finding. If it's just people sticking together, you don't get much information out of that. That's going to be only one. Remember, look, we're looking at multiple methods of data collection. So we are not going to listen only to dad and his coterie of friends and pals and his direct family. We're going to listen to other people, including the people that the adversary is going to bring up. So it's a process in a certain way of giving everybody a hearing in a certain way in the case, and hopefully that will, out of which the truth will emerge.
Yes. And one more for you. What are some examples of parental alienation factors that you discover in your investigation and would have to report?
Parental alienation is a horrific and seems to be, we talk about, well, is it people drinking more during COVID? Certainly alienation seems to be more prevalent these days. I guess we weren't even talking about it 15, 20 years ago very much. By the way, the new term now is resist, refuse kind of dynamics in a family. So we've even moved beyond parental alienation. The term was originally termed by Richard Gardner, a psychiatrist who's deceased, but who was sort of a little bit of a father's rights guy. So clearly the thrust of the original ideas were that it was a mother who was withholding and poisoning children against the father. As the years have gone on, there's been a lot of research, a lot of looking into this. We see that the victim of the alienation can be either gender. Certainly dads can be very good at alienating children from moms. So it does go both ways. And we also know we have to do a kind of a differential, often in an evaluation, as to where there is what we call realistic estrangement of a child from a parent who's been abusive or neglectful, and where the child is turned off to the parent for reasonable reasons, as opposed to what we call a genuine case of alienation, where there really is a parent who's essentially brainwashing a child and turning them against the other parent. I will say that in my experience, more often than that, we get what are called hybrid cases, which is a kind of an admixture of some alienation and some problematic behavior on the part of that rejected parent. But that's certainly would be part of our evaluative process as to when a child is rejecting a parent, what all is going on.
And is the evaluator only court appointed? If my case involves international relocation of the non-custodial parent, can I choose the specialist myself? Thank you. Either the litigants would consent to an evaluator, or the evaluator would be court appointed. And that's my understanding. If you want to have a peer review by your own forensic evaluator, then you are welcome to do so, or have one act as your expert.
Yeah, I would agree. I mean, just because if you have a specific case of an international situation, it doesn't give you the right then to say, oh, I'm going to get Dr. Jones to do this evaluation. No, it's the same. The rules are still the same.
Yes. And Meryl, this question is for you. You mentioned that there may be reasons you would not want to call a forensic expert to get the report in. What might some of those reasons be? That you may not want to call a forensic expert to get the report in.
So if the forensic is very unfavorable to you or your case, you may not want that report to come into evidence. Now, the other side can simply call the forensic evaluator and pay them to appear to testify, and then the report is most likely going to come in. So you can't necessarily prevent it, but you could delay or try to make it harder on the other side. Generally when the forensic says bad things about someone or reveals, some truths about someone they don't want the court to know, that would be often when they don't want the report in evidence.
I may be wrong about this. My impression is that's not going to work. No, I don't think so. I think peer review is the way to go there, because it's a court-appointed report, so you can, I don't know that you can really prevent it from coming in ultimately if it's a court appointed evaluator, and one side certainly likes the results of the report. It's going to be very hard to keep it out.
And one last question for you, Dr. Heimowitz. Are you able to look into prescriptions that a parent is taking, and if that parent may or may not be abusing those prescriptions?
Yes, I mean, you don't have to be an MD to look into that. I wouldn't be able to prescribe medication, but certainly the litigant would have to disclose, just as they would have to disclose therapy that they've been involved with. They would have to disclose what medication they're taking. And, again, remember, you've got the adversary who's going to be helping providing the forensic with information with which they can look into. So, that information would be obtainable.
Well, thank you so much, Dr. Heimowitz, and thank you everyone for joining us on this webinar. At this time, I welcome back Patricia Fersch. Thank you.
Thank you.
So we just want to thank especially Dr. Heimowitz for joining us today. It's absolutely so interesting, I think, and I hope it was beneficial to those of you. The best advice is, of course, not to get into a disputed custody case, but as you already know, given the number of issues that were brought up and potential problems, sometimes it is unavoidable. We want to just announce at this time that the next webinar will be October 28th from 1 to 2. Again, it's Lunch and Learn. The topic will continue to be custody, and at that webinar, we will delve a little deeper into some of the problematic issues that bring parents, unfortunately, into a disputed custody case. A reminder, this will all be available on our website, which is pffamilylaw.com. And again, thank you all. Have a great day, and a special, special thanks to Dr. Heimowitz. We really, really appreciate it.
Thank you.